they will be absolutely perfect. There's nothing wrong with those electronic signatures on lease agreements. Then the next question, can we sign a will electronically? Well, because of coronavirus and because of the pandemic that we are going through, you can imagine, I think yesterday I had about 3 requests from clients to draft their wills for them. So I'm going to do that later today and email that to them. But I'm going to mention to them that it is important that they sign it correctly. Because of the pandemic, there's a spike in wills that has to be executed and people want to get their affairs in order. However, the Wills Act that regulate the formalities relating to wills regulate that the following has to be done or adhered to when you execute or when you sign a valid will. First of all, the testator must sign the will in the presence of 2 witnesses. So they must be in the same room. And obviously with social distancing and all those things, it makes it a little bit more difficult. So first of all, the testator or the person signing the will that's executing his will has to sign it in front of 2 witnesses. The witnesses must be there with him or her when he signs the will. The witnesses must then also sign the will in the presence of the testator and each other. And then the witnesses must be 14 years or older. The point being, with social distancing and all those things that are going on, it is difficult to get 3 people in a room, in close proximity to each other, in order to execute that will. The other thing is that a beneficiary of the will. So let's say, for example, I bequeath my estate to my kids, and my kids are older than 14, no problem with that. They cannot be the witnesses of my will. So it is a bit more difficult because this is my household. We are sitting here. Yes, we social distancing ourselves from other people. My kids are right here. So, gee whiz, man, I just want to use them to be the witnesses of my will. Then we don't have to involve other people to come in and witness, etc. The Wills Act says, no, hang on. The witnesses are not allowed to also be beneficiaries. That is not valid. You must get somebody outside who are not beneficiaries to come and witness your will. So that makes it even a bit more difficult with regards to social distancing and etc., what you need to do. And I know that the Fiduciary Institute of South Africa, when the lockdown was promulgated and instituted by Mr. Ramaphosa and government more than a month ago now already, when that happened, the Fiduciary Institute of South Africa wrote to the Minister of Justice and said, listen here, this is the issue. How are we going to protect people that need to execute wills? It is an essential service that has to be provided, and please, you need to give us regulations and institute rules and regulations as to how we can deal with the signing of wills. Can we maybe do it electronically? Can it maybe be done via video conferencing? You need to give us a way to get around social distancing, etc. So they wrote to the Minister of Justice more than a month ago already, but they have had no reply from the minister. But luckily, obviously, the lockdown has now been lifted to a certain degree for attorneys. So it is easier now for people to come into our offices and to come and sign their wills here with us, because we've got enough witnesses here. We've got face masks, we've got sanitizers, we've got everything in place. We've got temperature measure, we take your temperature. We've got all those things and questionnaires that the clients complete when they come into our offices, whether they've been in contact with somebody with COVID, whether they've had a temperature in the last 30 days. So we've got all the necessary procedures in place to allow people to come to our offices and to come and sign their wills here if they cannot get it signed or done at home with witnesses, etc. Because what other option do they have? I suppose before attorneys' offices opened up, they probably had to take a will to the spa when they're going to buy their bread and milk, and get maybe the teller or get the lady that works in the bakery section to maybe get together there and sign the will there, because there was no other option of signing those wills. And it's just interesting to see that with regards to the signing of wills, all countries want wills to be signed in the presence of witnesses, etc. They don't allow electronic signatures. I know that Canada and Australia have put in regulations now with the lockdown, which will allow a person to sign his will via a video conferencing. So that is sufficient to sign in front of witnesses via video conferencing. He signs his will, they confirm that they saw him sign his will, they allow that. But it's only Canada and Australia that allows for that. Nevada in the USA is the only state in the USA which allows for electronic signatures of wills. No other states allow for electronic signature of wills. It has to be done in the presence of the testator, in the presence of witnesses, and that is obviously to prevent fraud, to make sure that fraud doesn't occur, that I don't go and forge my wife's signature on a will. No. There must be witnesses to have a look and see who made this signature right here. So it's to prevent fraud, and that is why a testator will sign in front of two witnesses, where the witnesses confirm it was Hein that signed this will. Absolutely, it wasn't his brother that tried to fraudulently fake his signature on a document. But then we've got an interesting case, McDonald versus the Master's Office. Just quickly, I see here that we haven't set out the facts of this case. What happened was Mr. McDonald, unfortunately, committed suicide. A couple of days before he committed suicide, he drafted his will on his computer at his office. He worked for IBM, by the way, the computer company. When he committed suicide, he left a handwritten note to confirm that he is Stuart McDonald, ID number, whatever. His will can be found on his personal work computer at IBM. His will was saved under my documents /my will /personal. You can have access to my computer with the following password. So what happened was the wife obviously went to IBM. The IT guys at his office then got his password from her. They logged onto his computer. They found the will that he drafted. They printed it for her and they gave it to her. They said, okay, well, that's the will that Stuart drafted exactly 2 days ago, because they can obviously follow and see the time and date and when he drafted it. So they said, so they certified it. This will was drafted 2 days ago. It was drafted by Stuart and it was done by him on his personal laptop. The wife then took this to the master's office and said, Mr. Master, I've got Stuart's will here. Here we go. It's an electronic will that we downloaded from his work computer. And the master said, hey, I can't accept this will. I don't have the authority to accept this will, because the master is guided by the Wills Act. The Wills Act will tell the master what he can accept and what he can't accept. So it's not for the master to decide. So the master said, but I can't accept this will because the Wills Act says that it must be signed by the testator. It must be signed. His physical wet ink signature must be on the document, and it has to be witnessed by two witnesses in his presence at the same time that he signed it, which obviously did not occur. This was just a draft will which he created on his computer. So the master couldn't accept that will because they didn't have the authority to accept the will. So the wife then had to take the will to court with all obviously with all the information and the circumstances surrounding that will. So each and every application to court to allow a will to be valid if it wasn't executed properly, will depend on the circumstances of each and every specific case. But in this scenario, the court found that it was a valid will, absolutely. And what they said was that the reason why they will consider this to be a valid will is because it was drafted by the deceased. From the evidence, from the IT experts that came to give witness and to give their expert input, it was only Mr. McDonald that had access to his computer. It was only he that utilized his password to get into his computer system. The other fact was that the deceased died after the will was executed. So the will was executed and drafted by Mr. McDonald on the 14th of December. Mr. McDonald passed away on the 16th of December. So there was no tampering with the will since Mr. McDonald passed away, since the 16th of December. Nothing happened to that document on that system since he drafted the document on the 14th, and nothing happened to it after the 16th of December. So the court said there is no doubt that no fraud occurred. Nothing happened to this will after the 16th, after Mr. McDonald passed away. And further, the court said this was obviously intended to be his will. They said that on the evidence, he left a handwritten note specifically alerting the family to the fact that he has a will. He specifically told them exactly where they could find his will with his password, and that is where the IT specialist found his will. So the court decided they will accept the validity and they will consider the will to be valid, and the master then had to act accordingly. But that is obviously something that you don't want to do. You want to do your will properly so that the master will accept your will. The testator must sign it. It must be signed in front of two witnesses, in the presence of two witnesses, because you don't want to have to go to court to pay thousands and thousands of rands to get a court to confirm that, okay, this electronic document, we will regard that as the valid will of the testator, despite the fact that there were no witnesses, despite the fact that he didn't sign it. But they will have a look at all those factors and consider the validity of the will. But it's going to cost a lot of money to do that, to go run off to court to get a court order confirming that it is a valid will. Then there's also new legislation relating to the deeds office. As we all know, there's the electronic deeds registration system that has been signed into law in 2019, last year already. So as is of deeds to implement certain procedures and regulations and systems that will allow for the deeds office to operate electronically. So that will allow the prepping of documents. So when we prep a title deed, or we prep a power of attorney, or we prep the transfer deed to receipt or the rates clearance certificate physically with the wet ink, we sign that and we stamp our name. What they want to do is they want that prepping of those deeds to be done electronically. So they are busy working on implementing certain rules and regulations, what they will allow for the prepping of deeds to be done electronically, for the lodgement of those deeds to be done electronically. So we don't have to physically go in with our lodgement cover, with all our deeds, a copy of the power of attorney, copy of the title deed, copy of the rates, all those documents. What we do is we physically go into the deeds office and we lodge that hard copy, those hard copy documents with the wet signatures, we lodge that at the deeds office. What they want to do is they want to do away with that. They want to get rules and regulations in place that allow the electronic lodgement, the electronic registration, the electronic storing of information at the deeds office. So they want to move into, it's obviously going to speed up the turnaround time with regards to the registration of transfers at the deeds office. But they are in the process of adapting rules and putting certain formalities and procedures in place for attorneys and conveyancers to do that electronically, to prep, to lodge, and to register deeds electronically at the deeds office without physically having to go into the deeds office like we currently do. So currently we go physically in, we go and lodge the deeds. Physically we go in when we do the registration deeds at the deeds office. We physically go into the deeds office and we go and sit there at the execution room to execute. So this electronic deeds registration system is trying to do away with that, which will be absolutely fantastic. It will speed up the process and it will make the whole system more efficient, and it will allow you guys to also log on to the deed system and track your matters yourselves. If if you're not happy with the weekly updates that you get from attorneys and you think the attorney's lying to you, the deeds have not been lodged, you can physically go and track matters at the deeds office as well. So that is an exciting development in this e-business, e-commerce that we are growing towards. That act will make life a lot easier for us as well, and everything will happen electronically. So, can you sign an OTP during lockdown? The ECTA, the Electronic Communications and Transactions Act, does not apply to contracts that are subject to the Alienation of Land Act. So, of 1981, by the way, you will see that it's Alienation of Land Act 68 of 1981. So the Alienation of Land Act does not allow for electronic signatures. So when you sign an offer to purchase, it has to be signed by way of wet ink, by way of an actual pen signature by the purchaser or the seller. It has to be signed by pen. It does not allow for electronic signatures. So you cannot conclude an offer to purchase by way of a digital signature. Not even if it is an advanced digital signature with passwords and encryptions, it is not allowed. You may not utilize any electronic signature when you sign an offer to purchase. This does not exclude the possibility that one may transmit the signed document electronically. So what they mean there is that, yes, I, as the purchaser, I can print the offer to purchase at home. I can sign it physically with my pen. I can sign the offer to purchase. I can then scan it and send it back to the agent, or I can send it back to the seller. So that is absolutely fine. You can send that agreement electronically via email or scan facility, as long as you have manually signed that offer to purchase. So you still have to manually sign the offer to purchase. You cannot sign it electronically. And there are certain apps or programs that you can utilize to obviously scan a document. So you might have a printer at home, but that printer doesn't allow you to scan the document back to the estate agent. So in that scenario, Cam Scanner, Tiny Scanner, Adobe Scan, ScanBot, all those scanning facilities where you pretty much take a photo of the document that you have signed, and it is as if you have scanned that document into your email, and you then forward that physically signed document that you've now scanned, you've emailed that back to the estate agent or the seller. So as a last resort, should neither party have printing facilities, because that's the major issue. If I can't print this document, then I can't physically sign it, because the Alienation of Land Act doesn't allow me to sign it electronically with my smart pen or with my trackpad on my computer. I'm not allowed to do that. So now I can sign it, but what do I do if I don't have a printer at home? It would be possible to give a written authority to the agent, maybe to the attorney or whoever, to sign the document on that person's behalf. So I, as the purchaser, I go through the offer to purchase, I have a look at it, I've got email facility, thank heavens for that, but I can't print it, I can't sign it. I can then give a written authority via email to the estate agent or to the attorney to please, I, Hein Daisel, with the following ID number, unmarried, hereby authorize you, the estate agent, Mimi, to please sign this offer to purchase on my behalf. I authorize you to do so, and that will suffice. But luckily, obviously, the other thing is that the lockdown has been lifted. So what we can do is, and what we do, estate agent will email the offer to purchase to us, and the estate agent will request us to get hold of the seller and get hold of the purchaser for the parties to come into our office to sign those documents, to sign the offer to purchase, and to witness the offer to purchase in our office. So we will be more than happy to assist with that. But point is, our offer to purchase cannot be signed electronically. Not at all. It has to be signed by way of a pen. So the parties can sign it at home as long as they've got printers and they've got scanning facilities. They can sign it and scan it back. That's absolutely fine. So they can send the offer to purchase back electronically, no problem, with email or scanners or whatever. But they have to print it and sign it with a wet pen, a physical pen. And if they don't have printers, well, then they need to give their attorney the written authority to sign the offer to purchase on their behalf, or they will have to come into the attorney's office. Thank heavens we are open now, and they must come and physically sign those documents here at the attorney's office. So in conclusion, it is clear that we've got legislation. We've got laws relating to electronic transactions, e-signatures. We've got ECTA, which is fantastic. It's been around for many, many moons. The courts have also looked at these things. And in conclusion, I'm also going to tell you about another interesting case quickly that wasn't on the notes, but that I remembered about. I must just try and find it, but I will tell you now about it. So our law accepts and confirms that electronic signatures are valid. Absolutely. Parties can use electronic signatures, whether it is by way of e-signatures, SMSs, WhatsApp messages, emails, digital signatures, where you've got a smart pen and you can sign a document, or advanced digital signatures, where you've got your own. Those signatures are all seen as valid, bar some contracts that cannot be signed electronically, such as a will or an offer to purchase or long-term lease agreements, etc. But our law does allow for electronic signatures on certain documents. And, in the current situation where we are going more and more into e-commerce and e-business and doing everything electronically like we are doing today, there is there's a bigger demand for electronic signatures and electronic documents than ever before. And yes, some of the laws, some of the legislation will have to adapt. We will have to have a look at the Wills Act to maybe get the authority and change the regulations in order to allow for, at the very least, advanced electronic signatures. But just in conclusion as well, there was an interesting case in KwaZulu-Natal. It was a matter of, I'm just trying to think of the name now. Versus Wilbury. It was a trading company versus Wilbury. This Spitfire Trading Company, or whatever the name was. But anyway, what happened was there was a lease agreement in place between Spitfire Trading Company and Wilbury. The Spitfire Company leased certain car cleaning machinery and equipment from Wilbury and fell in arrears with rental. They then had a meeting around the table where they discussed the way forward and how to resolve the arrear rentals and all those things. When the meeting was finished, everyone went back to their offices, and Wilbury emailed Spitfire to say, listen here, Spitfire, you are in arrears with your rental. You know what? I'm happy to cancel this lease agreement. Let's cancel the lease agreements with regards to the rental of car cleaning equipment. Let's cancel it on condition that you return the equipment to our offices and that you pay any arrear rental as at today. Pay all arrear rentals, then we cancel the agreement. Spitfire then emailed back to say, gee, that's absolutely perfect. I accept it. I'm happy then to cancel it, and I will come and return all the equipment and I'll pay all arrears. What Spitfire then did, they took all the equipment back to Wilbury. They paid all arrear rentals, and that was it. Wilbury then said, no, hang on. In terms of that lease agreement that we have, there's a non-variation clause there. The non-variation clause in the contract that we signed clearly states that no addendum, no amendment, no cancellation of this lease agreement will be valid unless it is in writing and signed by both parties. So no, we are not going to allow you to get out of the lease agreement. We will continue with the lease agreement. So what happened was Spitfire Trading Company then took Wilbury to court and said, no, we cancelled this, and the court had a look at the facts. And the court decided that those emails, after they had their meeting, the email from Wilbury to confirm that one of the options were to cancel the lease as long as the equipment is returned and the rear rentals are paid, and the acceptance of Spitfire, where they accepted to say, okay, that's fine. We agree to the cancellation, we will pay. Those emails with the electronic signatures at the bottom of those emails are sufficient to cancel the agreement. So the non-variation clause, it has to be in writing, signed by both parties. The court said that e-signature, those emails, that is a variation of the agreement. That is an amendment to the agreement. And those e-signatures on the emails are sufficient. We will accept that as valid signatures of the parties. So that's just the interesting case where the courts have decided and ruled on this to say that signatures, e-signatures, like in emails, is sufficient in order to amend contract or to cancel contract, which is quite interesting. So we are getting there. The courts have already changed their view with regards to electronic signatures. We've got our own legislation in place that allows for electronic signatures bar certain agreements, such as OTPs, wills, etc. So if you do have any issues with regards to the signing of offer to purchases, if the parties don't have printing facilities at home where they can sign it and then scan it back to you guys, you must get hold of your attorney and to your local attorney, discuss this with them. Their offices are open. They must accommodate you. If the clients don't want to give you guys the authority to sign the offer to purchases on their behalf, then the attorneys will have to arrange for those clients to come in and to come and see the attorney to sign those documents, because the attorneys will have all the procedures and will have all the precautions in place for people to come in, and those people are authorized to go and visit the attorneys to sign those documents on their behalf. So good luck. Stay safe. At least we can travel a little bit as attorneys, but not too much, only from home to the office. Clients are allowed to come and see us. We give them certificates to come and visit us at our offices. So we are not allowed at this stage to really travel to clients to go and visit them, but we are open to see clients and to consult with clients on a daily basis. So good luck to you guys. Keep safe, and we'll chat again soon.
Can I just ask a question, because obviously it's very relevant to what's happening now. Thank you for your presentation. Very good and very interesting. Hein, can you just give us a little bit of an update with regards to the deeds office? I mean, when exactly are they expecting it to open? And I think more importantly, for a lot of the agents that were sitting with deals that were already lodged in the deeds office at the time that we went into lockdown, what is going to happen with those deals? Are they going to have to be withdrawn? And what about those deals that were pending that you were about to lodge? Because I think, from a lot of the agents that have connected here today, I think a lot of them were waiting for deals to be registered, obviously waiting for money. And that's the big thing right now, is obviously everybody is financially very stressed. And so if you could just give us a little bit of an update on the expectations of the deeds office going further, please. I think it's very relevant to where we're all sitting at now in the industry.
Absolutely. So, Michelle, I obviously know what the Cape Town Deeds Office communicated with us. So I'm not sure, obviously, in the Bloemfontein and all those levels, but for Cape Town, with regards to opening up, they opened up on Monday. which was the 4th of May, the same as attorney firms and all those lovely things. So they were authorized by the minister to open their offices, which they did. But what they communicated to us was that they are currently only opening up their offices for staff members. So staff members, admin staff, etc., they are coming into the deeds office. They are not open for any attorneys or conveyancers or the public to come in there, purely because in order to open an office, like what we had to do, for us to be able to open, we had to get hand sanitizers, we had to get masks for people that do come into our offices that don't have their own masks. We have to issue them with face masks. We have to make sure that they are sanitized. So we had to do all those things. We had to get these, these thermometers that you take the temperature of a person, electronically. We had to get that in place. We had to have questionnaires at the reception desk. The clients coming in has to complete that questionnaire before we will see them. So they must have a face mask. They must sanitize themselves. Their temperature must be taken. After that, they must then complete a questionnaire stating whether they've been in contact with a person with COVID-19. It's about 5 or 6 questions. But we had to have that in place for people, outsiders, to come into our offices. The same applies to the deeds office. So the deeds office, they are now in the process. This week, they are utilizing to get hand sanitizers, to get face masks, to get electronic temperature measuring equipment. We got another writing. They've bought tape where they could tape, obviously, certain areas that for 1.5 meters or 2 meters. If you go, for example, to the lodgement counter, they want to have tape there indicating where you are allowed to stand and how far you should stand away from each other. So that is, the Cape Town Deeds Office is open, yes, but they're not open to the public as yet, purely because they've got to get those procedures in place for the public, like conveyancers, to go into the deeds office. So yesterday they again sent a notification around to say they are in the process of getting those procedures and regulations in place for them to allow conveyancers to enter into the deeds office. And they will advise us. Once they've got their regulations in place, hopefully, we don't know either, Michelle, because they haven't told us when they will be open for us to go and lodge documents at the deeds office. When will they be open that we can register at the deeds office? And what will the procedure be? Will there be only one conveyancer from an attorney firm to enter into the deeds office? Or will we still be allowed to have like 2 clerks? Will we have 2 conveyancers at the execution room like we normally used to have? We don't know that. So yes, the deeds office is in the process of getting their rules and regulations and procedures in place that will allow them by law to open up to the public to enter into the deeds office. And once they've got those procedures in place for us to go in there, they will also advise us what the rules and regulations will be with regards to the lodgements of deeds and the registration of deeds, as well as what's going to happen with those deeds that are in the system. They are discussing the fact that, look, the deeds office system is a computer system, and if the deeds did not register within 5 days after they came up for registration, they are automatically rejected by the deeds office computer system. But they're busy working with that. And they want to try and amend that computer system to allow the deeds that were lodged before the lockdown, that is still stuck in the system there. They want to try and allow those deeds to remain there as long as the rates clearance certificates have not expired. But they're also looking, even if the rates clearance did expire, they might allow us to quickly get an extended rates clearance to hand in. But those are the things that they are busy discussing amongst themselves at the deeds office during the course of this week. And then they will advise us, hopefully by Monday next week, whether we can come back and what is going to be the scenario with deeds that have already been lodged and that is sitting there in the system with them.
Fantastic. Thanks, Han. I see you do have a question from Gil, and I actually think it is obviously him being a franchisee owner, and we do have other franchisee owners that have logged on. I think it is a very relevant question because you guys, obviously, you've already been allowed to open. So his question is, can he have a list of everything that has to be in place once they're open? And is it possible for you to email him that questionnaire? Because obviously the other offices, we need to open.
Giel, dit sal 'n groot plesier wees. Dit is lekker om jou naam te sien. Flip en ek het jou lanklaas gesien. Maar Giel, natuurlik. Ja. Ek sal dit vir jou e-mail. Daardie dokumente sal ek vir jou e-mail. No problem with that. And Martin, hi there, Martin. It's so nice to see your name as well, man. I haven't spoken to you in a long time since Stableview days. But yeah, nice to see all of you guys. And Giel, absolutely. I will get Lani to send that to Michelle and to everybody so that you've got that questionnaire list and stuff.
Then we'll distribute it, because obviously the thing is, we understand that the industry leaders are trying to do their very best to try and get real estate open and trading again. So obviously whatever the business owners can start to put in place now, so that when that day happens, is that you are ready and open and ready to go.
And that you're up and running and ready to rock and roll as soon as you know that you can open. Absolutely, no problem. So yeah, I will get that list and all the procedures that must be in place. I'll get Lani to email that to you guys today still.
That'll be fantastic. And you'll send us that link for the Zoom meeting.
Absolutely, for the lease agreement.
Paying and
the lease, and everyone wants reduction in rental and all those lovely things. Absolutely.
Great. Thank you so much, Han. Much appreciated. Really, thank you for your time and your input. It's been invaluable and we really appreciate it. Thanks, Han. Have a good day further.
Thanks, man. You